Distinguished panelists, ladies and gentlemen, dear colleagues, a warm welcome to all of you. My name is Nadia Sporosheva, and I'm an Economic Affairs Officer in the WTO's Intellectual Property, Government Procurement and Competition Division. And it's my great pleasure to moderate this event on the WTO Agreement on Government Procurement Knowledge Series on the theme not just market access, the GPA 2012 as an instrument of good governance in government procurement. There is an important relationship between government procurement and good governance. Good governance means performing public services competently for the benefit of all citizens. The current version of the GPA 2012, entered into force in 2014 and expanded on the specific components through which the GPA promotes good governance. These components include at a minimum transparency requirements, prevention of conflicts of interest and corruption, accountability mechanisms. Furthermore, several recently acceded GPA parties considered the GPA as a driver of domestic government procurement reform and a means to lock in such reforms post-accession for the long term. Today's event will discuss all these GPA components and their contribution to promoting and strengthening of good governance in government procurement. I am delighted to have with us Caroline Nicholas, who is the head of technical assistance and senior legal officer with the International Trade Law Division of the United Nations Commission on International Trade Law. She has extensive expertise on the ancestral model law on public procurement and supporting public procurement reform worldwide. We also have with us Darina Harchenko, who is an international procurement policy advisor with the EBRD GPA-TC facility, and who supported several concluded and ongoing GPA accession processes. Our first speaker is Susan Brown-Shafi. She is an independent educator and public policy trade advisor who researched extensively in the area of public procurement, including its good governance dimension. So without further ado, let me start with the first opening question. As everyone knows, the GPA is a WTO agreement. As such, it is an international trade instrument. So why does a trade agreement include elements designed to promote and maintain good governance? Is that not an internal matter for each country, for each WTO member? But perhaps I'll start with giving the floor to Susan Brown-Shafi to start this discussion on this matter. Susan, you have the floor.
Thanks, Nadia. And yours is an interesting question and not a politically straightforward one to answer, particularly if one takes into consideration the historical evolution of the GPA's good governance disciplines and the wider political challenges of the international regulatory harmonization process of which they're a part. A relatively simple answer, in any case, might be found in the text of the GPA's preamble. That preamble says, "The integrity and predictability of government procurement systems are integral to the efficient and effective management of public resources, the performance of the parties' economies, and the functioning of the multilateral trading system." Speaking in the aftermath of the 2008 financial crisis, an earlier series of high-profile corporate governance and procurement scandals involving companies like Enron and WorldCom, and at the time that the text of the GPA 2012 was formally still under negotiation, the former Director General of the WTO, Pascal Lamy, addressed these concerns in a technical seminar for GPA members and observers. He said, "The mere removal of obstacles to trade may not by itself ensure optimal performance if rules are not in place to ensure fair procedures, appropriate transparency of markets, and responsible competitive behavior that is environmentally sustainable. It is time to recognize that such rules are an essential counterpart to market opening." This is the well-known idea of harnessing globalization that Mr. Lamy and others have subsequently addressed. The idea, that is, that markets require adequate accompanying governance mechanisms if they are to function properly. The GPA committee had been engaged with these issues for some time. Indeed, provisions for minimal ethical standards for GPA members' procurement processes had already been introduced in the 2006 revisions to the agreement. In any case, at that time, it was already clear that market access opportunities created by the agreement were at risk in the absence of minimum good governance in the domestic government procurement systems of the countries where the new export opportunities had been created. Over to you, Nadia.
Thanks very much, Susan, for walking us through the GPA preamble and also some of this historical background back then, and then the GPA agreement was renegotiated. Thank you very much for your perspective. Any other speakers would like to take the floor? Caroline, perhaps?
Yes, thank you, Nadia. I think this is a very important question, and I'd just like to add to what Susan says, a little bit of UNCITRAL background. As you mentioned, UNCITRAL is the United Nations Commission on International Trade Law, and so quite often we're asked, well, why are you dealing with public procurement? And the answer is very simple. From a general perspective, and echoing what Susan's just said about Pascal Lamy and his comments, our work is based on the idea that you only encourage cross-border commerce, whether it's government to business or business to business, if there is legal predictability and certainty. And you don't have that when there is just a competing rules, different rules, and also people don't understand how those rules will be implemented in practice. So the idea of having international standards that are completely voluntary, like the GPA, which is plurilateral, the UNCITRAL model law is simply a model people can use. That if you have good internationally agreed best practice standards that can help you improve your domestic provisions, that will encourage confidence to trade domestically and start removing some of the additional overhead that cross-border commerce otherwise involves. So we are really at one with the WTO GPA here. And I might just add, if I can go off message a little bit here, there are lots of international texts of various types on public procurement, and we work very closely together because the best thing for governments is to know where the international community agrees, and having researched these things, how public procurement standards domestically can be improved. And the GPA from that perspective and the UNCITRAL model law are designed in part to help governments improve outcomes in public procurement. And since it represents 15% and upwards of GDP in a country, that's a really important thing to do. Thank you.
Thank you so much, Caroline, for putting it into broader framework and referring to the UNCITRAL model law and about coherence of various international trade instruments. So I guess on that note, we will go a little bit into the specifics of the GPA and also looking at the synergies, including the UNCITRAL model law in that regard. So our first component in relation to good governance, which we are going to discuss, relates to transparency and publication in government procurement. And transparency is a very important concept under the GPA. The GPA requires to publish and provide information in relation, well, first of all, to individual public procurements by the GPA parties. This includes information in relation to ex-ante public notices on individual procurements, including in one of the WTO languages, also information on tender documentation, and ex-post information to participating suppliers and their governments, and public notices on the contract award. The GPA also has specific transparency requirements with regard to procurement systems of its GPA parties, such as information on each party's procurement system and also information relating to reporting statistics to the WTO. So perhaps, Caroline, we start with you, continuing on your previous intervention. In the introduction to the GPA, the preamble, the GPA parties collectively stress the importance of transparent measures regarding government procurement and of carrying out procurements in a transparent manner. Could you please explain why transparency is such an important good governance aspect based on your experience?
Thank you, Nadia. That's a really excellent question. And I just want to summarize a brief point here, that the points that you emphasized from the GPA are common to all international standards on public procurement. And that's not a coincidence. We all recognize these as very important points. And perhaps I'll just explain, to go to your question, why it is such an important and a good governance aspect. And I'll do that by separating two elements or two dimensions of transparency: an external one, which is most of what you've summarized, and an internal dimension. So to start with the external one, I summarized the provisions that you have about telling the world what's going on in your procurement system, both at a general level and for each procurement, as a full disclosure of all of the rules of the game and a no surprises rule. So the idea is that everybody participating knows exactly what to expect, and importantly, that allows them to decide in advance whether or not to participate. So that's from a supplier perspective. From a government perspective and from our perspective as citizens, when all of these standards and rules are disclosed, we can see whether or not the rules and the rules are being followed, and to some degree, whether the objectives of the system are being complied with or being achieved. And this is really important because we pay for the system. UNCITRAL has a little bit more detail on a couple of these external areas, just because ours is a template law rather than the GPA, but they're completely consistent with what the GPA says and help implement the principles that you've set up. These include, for example, public opening of tenders, and then to go to the internal dimension, a requirement for a record of the public procurement, each public procurement procedure. And this is vital because in all procurement, there are discretionary decisions to be taken, starting with engaging in the procurement, and then how you set up your evaluation criteria, your qualification criteria, and so forth. And so you need to be able to identify how that discretion has been exercised. And that's why the internal dimension and keeping records is so important. I might just add too, that when you have e-procurement, which I know the GPA encourages, you have systems that allow the oversight and the review and the assessments to be much more easily accomplished, and it reduces the burden of complying with transparency requirements. So it's a very important practical consideration. And I'd like to highlight here, if I may, that particularly so far as developing countries are concerned, the importance of having systems that are practical and reasonably easy to operate, because the overhead burden of traditional systems is so high. So the reforms of the GPA in that perspective are very important. And another point that we have seen, and just to emphasize that the GPA, like the UNCITRAL model law, is applicable all over the world, not just in developing countries or transition countries. We saw in the European Union, where I am based, huge problems over transparency in public procurement for emergency PPE and other COVID-related requirements. So we can see, we may think this is an easy concept, but it isn't. And when things get challenging, we really do have to remember how important transparency is. Thanks very much.
Thank you very much, Caroline, for expanding on both internal and external dimensions and also referring to e-procurement. Indeed, that was very useful, and also for providing these specific concrete examples. So I think on this note, I would like to ask Darina Harchenko, based on her experience, because she worked with various developing countries, with regard to their public procurement reform and the countries who are acceding to the GPA. Based on your experience, was a lack of transparency a factor behind the GPA accession and reform? And maybe you have got some examples where you saw that the GPA accession has helped the country achieve greater transparency. Darina, over to you.
Thank you, Nadia. So definitely transparency issue is one of the most important factors that lead, unfortunately, to waste of public funds and to inefficiency in public procurement. And for the majority of countries, as Caroline highlighted, and in particular for the ones in developing status, so the conducting of reform and the increase of transparency is one of the main objectives on the reform agenda that help countries to improve overall the economic development and the efficiency of use of public funds. Speaking about the recently acceded developing countries, and in particular, if you allow me to focus on Republic of Moldova and Ukraine, which are the two developing countries that have negotiated and completed the accession almost in parallel in 2016. So we can see that in both of these countries, the focus on increasing the transparency was one of the main ones in conducting the reform in public procurement. And also the GPA accession as such has strongly encouraged these two countries to continue with further increasing the level of transparency, because it's important once one of the objectives is achieved, not to stop, but to continue the work and reform in the same direction. And luckily, both of these two countries have managed to achieve really good progress. Both of them just managed to implement two very innovative, I would say, and modern, based on open data e-procurement system. And as Caroline highlighted, this eases a lot, and it basically helps a lot governments and citizens in terms of achieving greater value for money and increasing overall the efficiency in public procurement. The corresponding new e-procurement systems implemented in Ukraine and Moldova, which is Prozoro and M-Tender correspondingly, make a huge difference actually. And citizens, first of all, and obviously business, both national and foreign suppliers, have the possibility to have real-time access to data on public procurement, have the possibility also to access all kinds of information in the system, even without being registered in the system. So they have access to notices, which are obviously in one of the WTO languages. More than that, they have open and unrestricted access to all tender documentation. More than that, they have, again, full access to award notices, to contracts, and more than that, civil society and any citizen actually can monitor in real time how the public money is spent. And if government, doesn't matter, local or central, is indeed doing what they say they are doing, on the one hand. On the other hand, of course, this is of huge help to the government itself to better monitor and improve its procurement. And what is very important, it brought huge savings to both Ukraine and Moldova, and which were in the initial stage of implementation, of course, very significant. But even nowadays, it's still on a pretty high level. So on average, we can say it's about 10% of savings, which of course gives the government the possibility to have more goods and services for better quality for their citizens. So Definitely, the GPA accession in case of both Republic of Moldova and Ukraine played a key role in increasing the level of transparency. And we see the visible results, not only for national supplier, for international suppliers, and of course from other GPA parties in particular, but what is most important for citizens. Indeed, GPA is a good instrument, and we are happy to witness this good progress in the recently acceded countries.
Thank you so much, Darina, for providing these examples of Moldova and Ukraine and about practicalities, how transparency requirements were implemented also through the e-procurement, and also about the concrete results which were achieved after the GPA accession. So that was very useful. And also you touched upon this point with regard to the possibility for citizens to control how money are actually spent by the government. So it actually brings us to the next question of our conversation today, which relates to the prevention of conflicts of interest and corruption. And as we have already discussed at the opening session of our discussion today, the GPA is quite a unique trade instrument because it has this extensive good governance dimension. But what is also interesting about the GPA, it is the first WTO agreement which explicitly refers to the problem of corruption in its text. And however, the GPA does not impose specific obligations to prevent corruption. The GPA rather requires that GPA parties conduct government procurement in a manner that prevents corrupt practices, and also refers in this regard to the United Nations Convention Against Corruption. So perhaps the first question to Caroline Nicholas. Many GPA parties are highly advanced developed countries. So why does the GPA then give so much emphasis to the prevention of corruption? Caroline.
Thank you. Well, I think there are two points in this question I'd like to bring out. The first is an indication that just because many GPA parties at the moment are highly advanced developed countries, that the standards are directed to them, I think is incorrect. And the second understanding that I think is also incorrect is that corruption is a developing country problem. So let's tackle the second one first. If you go to any internet search engine and put in corruption, procurement in any country, you'll get examples. It's everywhere. I'm based in Austria. We have corruption problems here. Just look at Vienna airport. There's all sorts of allegations around that. Anything that Austria can do, the Germans are said to do better, and they have similar problems, but on a bigger scale with their Berlin airport. I come originally from the UK. You can find it there. So it is everywhere. And so the emphasis on preventing corruption is really important. And I want to put the emphasis here on preventing corruption. If you say in your text, you must not engage in corruption, it doesn't stop it. It just means it's against the rules. So what you need is an effective system of rules that in fact operate to prevent corruption. And so the transparency mechanisms that we've just been talking about are critical in this regard, because if you are fully transparent, you can see when things are not as they should be. I might also say that it's not good enough just to say you must not engage in corruption. Corruption is a part of anything that distorts the procurement process. And there isn't a standard definition. The UN Convention Against Corruption doesn't have a definition of corruption. So you have to be very careful about explaining what it is, the difference between principles and rules, what it is you want people to do and not to do. And UNCITRAL in particular follows what the GPA advises on the preventative element and talks about integrity, ensuring integrity in the procurement system through rules on transparency that we've been talking about, and also emphasizing, and you mentioned conflicts of interest, ethical conduct, fair conduct, And we have, as UNCAC requires, rules on declarations of interest and things like that. So then to go back to your first point, those rules are no less applicable to developed countries. As I said, there are all sorts of problems in developed countries, and the incidence of corruption is always very difficult to measure, because by definition, if you like, it is itself not transparent, but we know it's there. And so we all need to work very hard to follow these rules, and in particular the transparency rules, to try and prevent corruption in the first place. Final point, there's a lot of commentary about paying procurement officials properly to avoid their being in a situation where they feel they are justified in accepting distortions. And so there are very practical measures that we explain in the policy guide to the UNCITRAL model law that go into that level of detail. Thanks.
Thank you so much, Caroline. So many various questions to consider here. Thank you so much also for stressing once again the importance of this preventive nature of instruments in order to fight corruption and address these issues. Thank you. So maybe on this point, while we are discussing various instruments which contribute to addressing the issue of corruption, I have the question to Susan Brown. I mentioned earlier that the GPA explicitly refers to the UN Convention Against Corruption, and Article 9.1 of the Convention specifically addresses corruption in government procurement. If we compare the provisions of the GPA again against the content of this provision of the UN Convention, what can we learn? Maybe Susan, you can share with us.
Thanks, Nadia. I think such a comparison yields interesting results, actually. Picking up on some of the points that Carolyn's just made, if we go through the provisions of the GPA 2012 and compare them to the content of Article 9 of the UN Convention, it is clear that the two instruments are walking in the same direction, if you will. In terms of the letter of the law, what we see more precisely is that basically 4 out of 5 procurement-related anti-corruption obligations in the UN Convention are also obligations contained in the GPA. But from my more political perspective, what is even more interesting, however, is the spirit of the law, or the spirit of these laws, or their aims or purpose in the two instances. Although both agreements fundamentally promote sound government supported by robust and politically legitimate procurement systems, Article 9.1 of the UN Convention sets an international minimum standard of integrity in procurement, or ethical procurement. On the other hand, the relevant GPA provisions, to the extent that they overlap with those of the UN Convention, apply that standard to the specific context of trade in procurement, in covered procurement markets. So in line with the GPA's regulatory methodology of positive domestic disciplines that structure members' trade in covered procurement, these provisions effectively steer member states towards integrity in running of their government procurement systems. Another way of putting this, to conclude, might be that the GPA 2012 is designed to help countries operate government procurement systems that are positively effective in promoting ethical procurement. Government procurement in which neither corrupt practices nor conflicts of interest potentially undermine the market access benefits engendered by the agreement. Over to you, Nadia, sorry.
Thank you so much, Susan. Well, maybe on this interesting point, can I ask one additional question to you, a follow-up question? Also, you're a trade expert. Do you think that by opening government procurement markets to foreign suppliers from other GPA parties, trade itself can help address corruption issues, and how?
That's not an easy one for me, and yeah, I'd say I'm not aware of any specific studies that would demonstrate this, and I think I just better leave it there, if you permit me.
Sure, absolutely. Thank you, Susan. So then, for specific examples, I will refer to Darina Harchenko. So going by your experience of working with countries that are considering acceding to the GPA or that are in the process of negotiating on their accession to the GPA, are prior domestic problems with corruption in government procurement an important motivating factor? And does accession to the GPA, in your experience, enhance international investor confidence? Over to you,
Nadia. Yeah, it's talking about corruption and corruption in public procurement and in general corruption issues, of course, is not an easy topic and should be viewed like in a comprehensive approach. As highlighted by Caroline and Susan, it is definitely not only a problem in developing countries, so we can find it here and there, like in many developed countries as well. But definitely the problem with corruption in developing countries is much more, I would say, widespread, and we can find it in various domains and spheres of activity. And in public procurement, indeed, it was and it is in many developing countries still a serious issue. Also, when it comes to fighting corruption and preventing corruption, it should be conducted in a synergetic way. So it's not enough only to look from the corruption perspective, only to reform the public procurement sector and covering all the areas and the instruments that Caroline mentioned, from integrity, increasing the professionalization of officers and so on and so forth. But it's also coming together with the reform in the justice sector, which unfortunately is pretty weak in the majority of developing countries, and reforms in other domains with enhancing competition and working hand in hand basically with the anti-monopoly and competition institutions in the countries and so on and so forth. If to speak from the perspective of exceeding and recently exceeded developing countries to the GPA, obviously they are not an exception, and we had a lot of scandals, including high-level officials in Republic of Moldova, in Ukraine, even in North Macedonia and Kyrgyz Republic, and so on and so forth. Indeed, actually, one of the main reasons behind the reform, in particular in Moldova and Ukraine, was to fight corruption and to improve the situation. Together with increasing the transparency, together with the implementation of the GPA provisions when it comes to fair procurement, these two countries managed to apply in practice also some practical tools, I would say. And I would want to give here the example of the Republic of Moldova, the open money platform, that made basically a connection, a link between the e-procurement system and tender, the electronic registers in the Republic of Moldova, and due to the interconnectivity, they managed to identify, and it's obviously available for any user, they identify and track the real beneficiary of public contracts. So in this way, one could identify and prevent future corruption schemes and corruption issues that unfortunately are still happening, and officials are accused and even getting to prison from time to time, which is actually a sign that it is working. When speaking about the investors' trust, and in particular foreign investors' trust in the system, obviously, the improvement of the public procurement system and fighting corruption to a certain extent it has contributed to slightly improve of the perception, let's say, so of the investment climate in the country as such. But we must be realistic and say that just by improving one of the variables, it's not enough to have, a completely better investment climate and to increase a lot the investors' trust without taking into account many more factors. And in these particular countries, if we are speaking about Republic of Moldova and Ukraine, we should highlight that the political instability that is a reality for the last 8 years in Moldova, when we had basically each year a new government. Sometimes it was even twice a year, change of government. So obviously this cannot give too positive sign to foreign investors. So that's why we should look at this question from a synergetic and a complex point of view. But a good news, I would say, from this point of view is that both Moldova and Ukraine, they are implementing, besides the public procurement reform, which is going pretty well, and actually in both countries it's considered one of the the best examples of implementation of the reforms. They are going pretty strong, and with the recent changes in Republic of Moldova, it should be even at higher rates, implementing real reforms in all sectors, just in order to indeed improve the investment climate and to offer possibilities both for national suppliers and for international suppliers, and for international investors and for national investors, to do business, to feel safe in conducting business, and to know that the rules and the fair game rules apply and they are respected, and everyone gets what it works for, and everything is fair.
Thank you very much, Dorina, for sharing these examples of Ukraine and Moldova and what they did at the national level to address these issues. That's very interesting, and to hear about all the progress which countries made in this regard. You also touched upon an important dimension which relates to accountability mechanisms. So it actually brings us to our next point of our today's discussion, which is about GPA accountability mechanisms. So at the international level, GPA parties can use the WTO dispute settlement mechanism to enforce their rights. And at the domestic level, each GPA party must put in place domestic supplier review procedures. And you had already referred to those, Dorina, to which suppliers from a GPA party have access. So this is a dual dimension of the GPA with regard to accountability mechanisms. So I have the question to Caroline Nicholas. Caroline, how do you see the value of domestic supplier review procedures as they envisaged in the GPA? Is this an effective tool to hold procuring entities accountable from the perspective of suppliers from a GPA party?
Thank you, Dorina. That's a very good question. The short answer is it should be. It should be a very effective tool. I might just say that it is also required by the UN Convention Against Corruption, which talks about an effective domestic supplier review process. And here, the point that the GPA has, which is also the same one in UNCITRAL, is that effectiveness relates to the ability to overturn procurement contracts if they are incorrectly awarded. So, and that is one of the key points. It's corrective measures. So if there's an incorrect decision taken during the process, you can have that decision overturned. This is the primary objective, and that is why it can be an effective tool, because if you want suppliers to exercise their rights to challenge decisions, that's what a domestic supplier review procedure is about. They have to be able to have meaningful remedies. And what do suppliers want? They don't want some compensation years after the event. What they want is the contract. They're in the business of trying to supply to the government to win contracts. So this is why it is so important to have as a rule and a process available to suppliers, because those suppliers have the highest or the most immediate interest in making sure that the system is fair. That's what they're there for. They want to compete and to win contracts. So how does it work in terms of being an effective tool to hold procuring entities accountable? Well, you need several procedural steps. You need very clear rules that explain how procuring entities can take the challenge or submit a review process. You need rules to make sure that it can take place in the procurement context time frame, so that it happens before things become cast in stone. And so there are lots of supporting tools to make it work. For example, a standstill period between deciding who's going to win the contract and actually issuing the contract, because once a contract is issued, things become much more complicated because contract law gets involved. So I think the value of it, which allows the system to some extent, therefore, to be almost self-policing and self-enforcing, not completely, is very, very high. And that's why it is a fundamental pillar of ANCAC. It's a very important part of the GPA. And it is also a very important element. It's a whole chapter in the answer trial model law on this. There are very many different ways of doing this. Answer trial has 3 separate processes. Some are independent, or most are intended to be independent, but there needs to be also under UNCAC a 2-step process. So a first level review and an appeal mechanism. The other thing that is very important behind it is an educational function, so that we, when we see how things have gone wrong and why things have gone wrong in a review procedure, we can learn for the future. And so in addition to the immediate effectiveness of a domestic supply review mechanism, there is a longer term effectiveness point, because it has an educative value. And therefore, going back to transparency, it's really important that decisions on reviews are made publicly available so that everybody can understand what's gone on. Thank you.
Thank you, Caroline, for walking us through these practicalities about how it does work in practice. So that's very useful. Thank you.
I was just going to say, actually, I haven't worked with a country in an actual review process, but I know that Dorina has, in the context of the EBRD-TC facility and a related answer trial program. So she may have something to add from that very practical approach. Thank you.
Thank you, Caroline. Yeah, I would like to adjust a small example of how actually the reform in the review system was conducted following the GPA accession. And in particular case, I would speak about Republic of Moldova, although Ukraine also managed to implement some significant reform in this sector. But we had a particular problem in the Republic of Moldova. That's why I would like to stress this example, because for many years we had huge problem in terms of conflict of interest in the review system, because the same institution that was dealing with the elaboration and implementation of public policy was also dealing with the review of the complaints. And it also was the same institution that was actually approving the notices. And so it was a while ago. But GPA accession, the government and the country realized a significant reform was needed. And as a result, it was set up a new independent review body that was under and it is still under the parliament. And what is more important, what Caroline has highlighted, it focused a lot on the approach towards the review as such. So first of all, high transparency requirements were implemented. All the complaints, all the decisions, they are publicly available. More than that, hearings are public. So basically the level of transparency is very important. And what is also important when it comes to timelines for review, they also were and are strictly regulated in order exactly to ensure that the suppliers that were infringed, they have the possibility to still get the contract and to their rights to be defended. So in this case, we can say that indeed the GPA accession contributed to the improvement and significant change in the review system of the country. And what is important, and it is still kept, of course, that the decisions of the review body can be just appealed, and we have obviously the court that can rule whenever there is a problem. And following this reform, the trust by the suppliers and the citizens also has increased. And this is just not words, several questionnaires and interviews were conducted by the Open Contracting Partnership following the different phases of the reform. And indeed, we register a considerable increase of trust of citizens and of suppliers in the public procurement system and in the review body as such. Thank you.
Thank you so much, Darina, for sharing how it worked in Moldova about this process. And you again are stressing very much about the transparency component, that it was so much important during this process. So we see how it all linked together. Then we talk about good governance with regard to public procurement. So I would suggest that we move now our conversation and discuss the GPA accession and reform process. We have already touched this with regard to other points we have been discussing, but maybe we can go a bit further. And many of you know that sometimes countries are well aware of the need to reform and improve their domestic government procurement systems. However, the political situation may be such that it is not possible to get enough support and momentum for such reforms. Likewise, sometimes governments succeed in introducing valuable reforms, but later get voted out of office, and the next government might not have the same priorities. So it is interesting to explore the role of the GPA in this context. And I think the reference to politics has already been made with regard to our previous points. So I would like to ask the question to Darina Harchenko. From your experience as advisor in several recent accessions to the GPA of developing countries, can you confirm that acceding to the GPA has helped those countries implement domestic government procurement reform and also prevent their subsequent reversal? So quite a tricky one.
Thank you, Nadia. Indeed, a tricky question, but actually it reveals the reality that we are living in. And in developing countries and in transition economies in particular, the change of government is nothing, of surprise or unexpected, and it's happening much more often than one would want to. And on this occasion, obviously, different political changes bring different views. And very often, somehow, public procurement is in the center of the attention. And somehow, the new politics always want to touch upon it, and they consider that they know better. And unfortunately, in Armenia, although it's has more than 10 years of GPA membership, in the Republic of Moldova, in Ukraine, we had like a series of attempts, I would say. It wasn't, like a one event or like one attempt, but politicians, indeed, they tried several times to step back and to implement some changes in the legislation that would, for example, reduce the level of transparency, that would want to take out of coverage of the public procurement law of some specific sectors or entities that they like, let's put it this way, in a diplomatic way, or some other attempts, but fortunately, and precisely due to the fact that all these countries were GPA parties, and this was a strong argument why it is not possible to go backwards and to change in a negative way and actually reverse the reform. So it was possible to maintain the provisions that were in line with international best practice and in line with the GPA. And fortunately, all these attempts were without any result. And yes, from this point of view, we can confirm that GPA is, a very powerful instrument in locking in the reform and keeping, the progress going forward, and not going back, and not, change what was achieved with so much hard work. Because, as you mentioned, it takes, political champions, because reforms, and in particular public procurement reforms, they are not easy, and especially in the initial stage, it's very complicated and complex. So it's very important to keep what was achieved and to go progressing in the right direction. Thank you.
Thank you so much, Darina, for this insight and being so frank with us about your experience and what you have seen working with the countries which are acceding to the GPA. So my next question is to Caroline Nicholas. Through your work, Caroline, you have been involved in supporting domestic procurement reforms, notably in the developing countries as well. How do you see the value of international legal instruments like the GPA and the ancestral model law in this connection? So I guess Darina already touched upon some of these aspects, and if you can elaborate further based on your experience, that will be very useful.
Thank you. Well, the short answer to your question is that these tools are very valuable, because when we work with governments in developing countries in particular, but also in transition and developed countries, we come with a standard that's been negotiated through an international consensus building approach. So we show that this is independent of what I might call the sort of vested interests that Darina has been alluding to. So we can say this is an independent standard. It's been designed with a country's interests at heart. And so that's the value of it. And we don't come with an agenda. We come with a standard that says this involves both a commitment to international commerce in public procurement, but it allows for domestic policy imperatives, for example, supporting SMEs, to be followed. So it doesn't displace the policy freedom that governments have for some of their important areas. And very importantly, it embodies practices that help governments and help citizens to get the most out of their public procurement system. And not everything can be expressed in terms of rules. So both the GPA and the ancestral model are templates for the primary legislation. But as Darina has just been implying, the procurement system goes way beyond that, and it's how it's used. And I think to talk about the GPA and the ancestral model law as if they are sort of standalone plug and play sort of legal instruments is simplifying things a little bit too far, because what we have that goes with it is, well, this is a knowledge series on government procurement, but there is a comprehensive technical assistance program. I also made a reference to a policy guide to support UNCITRAL's text, which is the Guide to Enactment. It's not very helpfully named, but it's a very long policy document that explains why the model law says what it does and how it works with the GPA and UNCAC. And even if governments choose to take a different approach here and there, it explains the value of all of these provisions. And so governments really can use it to help reform and assess their own systems. So this is a supporting tool, not a tool to say you're not up to scratch. This is something that allows governments to own their own reforms and be accountable to their own citizens. And I think it's a very important tool in that sort of context, or both texts are very important tools in that sort of context. Thank you.
Thanks very much, Caroline, for sharing your perspective. And you also touched a very important point that the value of the good governance dimension is also quite important for developed countries, not only with regards to the conversation we are having in relation to developing countries. And I think Susan might share with us an interesting example in relation to developed country perspective.
Yeah. I do have an example of another example of a GPA as a driver of domestic reforms. The GPA 2012 entered into force in Switzerland, a country that originally acceded to the GPA 1994, 25 years ago, only at the outset of this year. And that is almost a decade after the latest revisions to the agreement were reached. And the reason why is because the Swiss federal government used the obligation of bringing its domestic law into compliance with the GPA 2012 as an opportunity to introduce a single modern procurement regime, incorporating harmonized cantonal and communal legislation. Prior to this time, Switzerland, a federal state, the Swiss central government, did not previously have a single uniform competence in this area.
Very interesting. Thank you very much, Susan, and to all of you for sharing these concrete examples of what has been happening and how rules of the GPA and other international instruments contribute to the good governance dimension. So I guess we are reaching towards the end of our conversation, but I would really like to give you the floor for any concluding observations and points you would like to highlight. Perhaps we'll start with Caroline. Nicholas.
Thank you. I think one of the things I'd really like to highlight is why this work is important. We've heard throughout our comments about the practical support and help that the GPA and the relevant programs and other international texts provide. But I'd just like to put a little bit of emphasis on why we've done this. And I mentioned earlier on that public procurement relates to perhaps over 15%, even more, of GDP, and it can be up to half of government spending. And it's really important to get this right. And not only is it just a question of money, but what do governments do with their procurement systems? They build infrastructure, they deliver services to the most needy citizens. And so getting this right is absolutely vital. And the tools that the GPA operates and provides, and the support that we in the international community can give to countries, is based on experience. We've heard from Doreen, we've heard from Susan, practical examples. These are not ivory tower instruments. These are instruments that have gone from practice to policy, and we are offering them as tools with support to help governments deliver these really vital services. And corruption is a really pernicious problem, but it's not the only problem. Getting the technical stuff right so you get the best outcomes is absolutely vital. So I'm committed to supporting all countries in procurement reform. We all face the same problems, and I'm really pleased to be able to work with tools like the GPA, UNCITRAL model, and indeed the UN Convention Against Corruption to help governments in that way. So thanks very much for the opportunity to talk a little bit about how we've operated these systems over the last decade or so.
Thank you so much to you, Caroline, for sharing your experience and expertise in this area. Darina Harchenko, the floor is yours for any last thoughts.
Thank you, Nadia. Just a brief summary, and just to highlight that indeed, basically, in our today globalized world, there is no other way than for countries to proceed and to contribute to their economic growth than by just getting involved and actively participating in international global flows and in international trade, and public procurement market is not an exception. And if countries want to further increase the efficiency of their public procurement system is by opening up, and GPA is a unique opportunity for that. And although many developing countries to a certain extent have the fears that, you know, once they will open up their markets, and the public procurement market in particular, their markets will be invaded by foreign suppliers. Actually, the reality, and we take the developing countries that are already GPA parties, and here we are talking about Armenia, Ukraine, Moldova, the reality is completely different, and to show that this by far isn't the case, and vice versa. It actually, the increase of transparency and enhancement of better rules in procurement and implementing in practice the GPA provisions actually helped these countries to increase the efficiency of their national public procurement system, while at the same time it gave the opportunity to their national suppliers to go on the other markets. And correspondingly, if we look at the total benefits versus the potential costs, by far the total benefits out of the GPA membership are much higher. That's why I would just want to highlight once more and encourage other developing countries to start from the very beginning, just with no obligations, go for the observership, and just observe from the inside what is happening, which are the potential benefits for them, what would be the potential costs for them, how it works. And following that already, with full knowledge and with full confidence, to go ahead and just start with the accession negotiations, because it is in their best interest. Thank you.
Thank you so much, Darina. Sounds very reassuring. Thank you for sharing these concrete recommendations for developing countries. That's very useful. So I would like to give the floor now to Susan Brown-Shafi for concluding observations.
Thanks, Nadia. And I'll pick up on some of the comments that Dorina and Carolyn had just made. And looking ahead with the benefits of my knowledge of the history of the GPA, I think that the government, the WTO, the Government Procurement Committee, will increasingly be focused not on disseminating standards to exceeding countries, but rather on fostering policy experimentation and learning amongst peers. To some extent, that's what's already happened, but I just think it's going to be the pick up pace and even more of that, because the governance challenges today are universal. And the big lesson I take from the committee's activities over the past 40 years is that collective efforts among states with very different treaty application landscapes can be productive, and politically credible rules, practices, and procedures are possible. Thanks.
Thank you so much, Susan. Well, I guess on this positive note, I would like to thank all of you for this very interesting conversation today, which is a part of the GPA Knowledge Series. So thank you so much for joining us today, and I wish you a good day and all the best with your work. Thank you.
Thank you very much.
Thanks, everybody.